Good morning. The first case to come before the court this morning and the only case to be heard this morning by video conference is In Re KJ. The state of Ohio has waived oral argument, so counsel, will have 15 minutes to present your argument this morning. Please do not use the names of minors or victims in this case, as we are live streaming and will be posting the recording on the court's YouTube channel. We have read the briefs and we are ready to proceed when you are.
Thank you, Your Honor. Good morning, judges. May it please the court. My name is Angelina Jingo, and I represent Darius Beverly, the father and the appellant in this case. The issue is whether the trial court abused its discretion when it placed the child in the legal custody of a relative, when we assert that Summit County Children's Services did not provide Mr. Beverly with reasonable reunification efforts. We also submit that the trial court's decision was against the manifest weight of the evidence when it placed the child with a relative. And lastly, that the court committed an abuse of discretion when it failed to grant a 6-month extension in this case. I would draw the court's attention to the case of In Re SR. And while that case is admittedly more extreme and a plain error standard was used, we submit that the facts are similar to this case and bear resemblance. In that case, paternity was established on the birth certificate. However, the agency never added father to the case plan. It's more egregious in my mind, and I think the court's mind, that father had attempted to contact the agency many times, and the caseworker misstated her testimony on the record. But in this case, I submit that a timeline is useful in analyzing our facts, in that in this case, an adjudication occurred on December 4th of 2019. Disposition occurred on December 9th of 2019. Father submitted to paternity testing on November 20th of 2019. Paternity was established on December 30th of 2019. And father asserted in a hearing in January of 2020 that he would like to be added to the case plan. However, father was never actually added to the case plan until June 23rd of 2020, and that was later adopted by the court in early July of 2020. A legal custody hearing was then held in early September of 2020, giving father approximately 2 months to submit and comply with the case plan goals as articulated by the agency. I would also submit to the court that the caseworker's testimony is important in this case. And the caseworker admitted on the transcript on page 54 and 65 that the agency should have added the father to the case plan back in January of 2020, but the father was not added until about 5 months after that point in time. Father also attended hearings throughout the course of the case, and we submit that father's constitutional and his statutory rights give rise to these reasonable efforts requirements, that our court and the Supreme Court has long recognized that unmarried parents and non-custodial parents have a civil right to the care and custody of their child. The custody care that power and to make decisions in this regard reside first in the parents, whose primary function and freedom include these obligations that the state can neither supply nor hinder. So we submit that the agency had these statutory requirements, but they did not make reasonable efforts. This
Counsel,
court has
let me-
also long
Counsel.
recognized that it.
Counsel, let me interrupt you. I'm sorry. I'd like to get into the issue of his visitation, his contact with the child. I understand it was during COVID. Well, we're still during COVID, but right at the beginning of the COVID mess. And so they said he only had 2 in-person meetings. Was that something that he elected to do, meaning that he didn't go more often, or there were only 2 presented to him?
Thank you, Your Honor. What I can glean from the transcript was that I think the legal custodians, the persons who were awarded legal custody, indicated that father had regular phone contact or electronic contact with the child almost on a daily basis. So I would also submit that during this time, I would encourage the court to go back and this was also not incredibly clear on the record, but during this time, COVID was really just beginning. And there was I couldn't point you to an exact page number, but there was a halt in visitation with the agency. So because a relative had custody, the father could visit in the home, but he was electing, I think, to visit via phone at this point.
That's what I remember that they said he had almost daily contact with the child via FaceTime or just calling. But I was just curious as to whether the agency or grandparent told him he could not visit during COVID. That's all I wanted to know.
I do not have a clear answer to that.
Okay, thank you.
In terms of what is reasonable in terms of the agency's actions, the standard is not whether the agency could have done more, but whether they did enough to satisfy the reasonableness standard under the statute. And I point the court again back to the agency's admission that they admitted that they should have done more. And father was not added to the case plan until 6 months after he made the request to be added. And then when he was added, the case plan was adopted by an order of the court in July of 2020. So in the short time that he had to work the case plan, his case plan goal was to obtain stable and independent housing and to provide for the basic needs of the child. And in the short time between the adoption of the case plan and the final hearing, he was able to obtain employment. And at the hearing, it was brought out through testimony that he had been employed for 2 weeks. And I assert that he made use of that time and that it was an abuse of discretion for the court not to find that those efforts within that short amount of time constituted substantial case plan compliance, and therefore it was an abuse of discretion not to grant the 6 months extension for this father. Because reasonably, one has to be employed to develop a savings to then put a down payment on an apartment. So in order to fulfill this stable and independent housing, he first had to have a job. And given the 2 months that he had, he was 50% there. He had complied with the case plan. Given the 2 requirements that he had complied with 1 at that point. 6 months, a 6-month extension would facilitate a permanent a permanency option for the child because father reasonably would have been able to obtain housing within that period of time. Father submits that this was the most appropriate course of action for the court to take, that given his constitutional rights and the statutory requirements of the agency, that additional time was warranted and additional care was warranted in this case. I would also draw the court's attention to two policy assertions in that we have been living in this COVID era since March of 2020. In this case involving father and the child endured for the early portion of that COVID time where there was a lot of uncertainty. And father did elect to do phone contact with the child, and he worked at having very regular contact with his child. There was even a period of time between the onset of the pandemic in March. There was a several-month period where the agency themselves were not allowing in-person contact. And the second policy item that I would submit to the court is something that this court's very familiar with, in that the parents' constitutional rights are given the utmost deference in our American system of justice. And that Summit County Children's Services was required to exercise reasonable efforts, and the court examines that under a reasonableness standard. The testimony of the caseworker was that she reached out to father. She approximated 15 to 20 times by phone during the course of the case. And that was her excuse for not adding father to the case plan between January and June of 2020, when father had already articulated as a desire to be added to the case plan. We respectfully submit to this court that a mere 2 months of allowing a parent to comply with an order of the court, to comply with this case plan that was adopted, is unreasonable. We submit that given the constitutional protections that he has and that he has under our law, that greater care was warranted. We're asking that the court reverse and remand this decision and require the agency to exercise greater diligence in affording father and protecting his constitutional rights. I'm happy
Thank you.
to take any additional questions.
Thank you, counsel. Seeing none, the court will take the matter under advisement. We will issue a written decision, which is mailed to all parties to this appeal, as well as posted on the Ohio Supreme Court website. Our next video oral argument is this Thursday, September 16th. Thank you again for your presentation this morning. Have a wonderful day. We are adjourned.
Thank you.